I want to now move to President Dorit Beinish, the former president of the Israel Supreme Court, somebody I've known now for more years than either of us would like to admit. I remember this very young, I hope you don't mind me saying this, very beautiful young woman who was the state prosecutor and regarded as among the most brilliant young lawyers in Israel at the time we first met. And then she was appointed to the Supreme Court of Israel, where she served as an associate justice with great distinction for many years, and then became the first woman president of the Supreme Court of Israel. I have a trivial pursuit question for any of you in the audience here. You know, Israel has been accused by the Council on Human Rights of being the most sexist country in the world. Can anybody here name the first prime minister of any country who was made prime minister without having been related to a previous political leader, either through marriage or through birth? Golda Meir, of course. And there haven't been too many countries. There have been some since, obviously Margaret Thatcher and Angela Merkel, but that's still a pretty good distinction. And there haven't been too many countries in the world who have had distinguished leading prosecutors and distinguished presidents of the Supreme Court who have been women. But I have to mention that Dorit Beinish will go down in history not as the first woman president of the Supreme Court, but as one of the greatest presidents and justices of the Israeli Supreme Court at a time when the Israel Supreme Court was under enormous pressure, both external and internal. So it's my personal pleasure and honor to introduce President Dorit Beinish.
This? No. Thank you, Alan, for this introduction. A bit embarrassing, but I thank you very much. Now, I must say it's not easy to speak now after this interesting morning we had and this testimony we heard at the end of the morning sessions. I thought this speaks for itself. But we have to speak about the future. And we are gathered here, jurists, academics, judges, and distinguished members of the legal community in the Jagiellonian University with its great historical significance and reputation. But this is not just another academic symposium that we are having when we refer to principles of criminal international law while we are sitting so close to Auschwitz, the site where the most horrific events that history has witnessed have occurred. So many of us were influenced, actually I think all of us, by those events in the personal, national, and global spheres. For me personally, I was lucky that I was born in then Palestine and later the state of Israel, because my parents were Zionists who came in time to Israel. But Poland was the land where my mother was born, where her family lived for generations, and my grandfather and grandmother and my aunt have managed to send the last postcard from the ghetto to congratulate my parents on my birth. Then they perished with all their family and relatives, of course, who died in Treblinka and in their village. So we all have our feelings and relations about what happened. Countries around the world chose to ignore the horrible atrocities and to shut their eyes to the systematic murder of millions of Jews, hundreds of thousands of other victims. Only after the Holocaust and the horrific events, the international community understood the meaning and the lessons derived from those events. The most important lesson was the perception that democracy is, in its essence, not only the rule of a majority, because you can elect in democratic elections dictators, and this was the historical story about Hitler. Democracy in its essence is the rule of law that guards fundamental values of the democratic system. The basic notion that all men were created in God's image, that human dignity is the value of the highest importance, and so is equality among human beings, regardless of their ethnicity, race, or gender. It is still hard to grasp the deep meanings, the results and the influence of the darkest era of our generation, and as it was said already this morning, by the most cultural society that Europe knew. We see together in this panel judges from different systems of law. We all have to overcome emotions and personal pain in order to fulfill our professional and moral common goal and commitments to protect human rights, to prevent future crimes against humanity. There is no doubt that the Nuremberg trials were the first and maybe the most important steps taken against the war criminals that were responsible for the terrible crimes. But we have to acknowledge that the trials were a reaction led by the nations of the free world who fought against the Nazis and took place at an early stage before the principles and norms of international criminal law were shaped and legislated. And of course, we heard today about the discussions and the different views of different leaders of the victory countries, what should be done with the criminals. I don't think this is a kind of question we can ask today. The next steps taken after the trials were the UN Declaration of Human Rights, the genocide resolution adopted by the UN General Assembly, later the Genocide Convention. Then the UN was a young institution that was a source of optimism and hope. I wish we could have the same optimism today. In my view, the next milestone was the Eichmann trial that took place in Jerusalem, Israel. The Eichmann trial was not only an important development for international law, it created a huge change in the history of the State of Israel and a deep change in the social and cultural life of our country, only 15 years after the war ended. For the first time, people in Israel and in the world could learn about what really happened there in the hell of concentration and death camps. More than 100 witnesses told their personal horrific stories. For the society in Israel, this was an earthquake. The survivors never spoke before about their personal tragedies that were hidden in their broken souls and bodies. Unlike the Nuremberg trials, which were based mainly on accusatory documents, the Eichmann trial exposed the events from the human perspective. A lot has been written by academics, experts on the various aspects and influence of the trial that changed the views and beliefs of the Israelis on what it meant to be a victim of the Nazi regime. The judges in the trial court, headed by Justice Landau, who later was the president of our Supreme Court, coped with the professional aspects of the trial. They showed greatness in their ability to listen to the witnesses, to understand their pain, and at the same time to be very professional in analyzing the legal problems and the evidence while taking important decisions interpreting the laws and norms of international society. In the brilliant judgment of the appeal court, written by Justice Aganat, it relied on the principles developed in the Nuremberg trials. He saw the Nuremberg trials as a legal precedent binding by international customary law. This is what he wrote in his opinion. He emphasized that at the early stage of development of international law, he had to follow the principles that were laid in the Nuremberg trials. In his opinion, he stated that when crimes against humanity and crimes of genocide are perpetrated according to the principle of universality, every state should act as an organ of the international community because the perpetrators injured the basic rules of international society and its security and violated the moral universal values and humanitarian principles, which are the basis of every criminal law system. The judgment was the most significant decision given by a national court judging international war crimes. The next steps that were taken by international community with the significant legal developments were already discussed here this morning. We had the conventions, the Genocide Convention, the Geneva Conventions, and the Rome Treaty, the Rome Statute, and the establishment of the International Criminal Courts. That not all the powerful, of course, and other states are, and it was also mentioned today, signed on the treaty. These are very important steps, but we should be asking the question, do these formal legal steps really provide a response to the great concern we share today on the infringements of human rights around the world? We live in a world where we still see communities and individuals exposed to mass murders, mass atrocities, where the violation of human rights and human dignity are still part of their reality. It is true that nothing could be compared to the systematic efforts of the Nazi machine to perform the final solution. Yet we still witness hatred, racism, religious intolerance, and anti-Semitism that raises its head now in different corners of the world. We may say that today we do have the legal tools to enforce nations to comply with the norms of a civilized society. And the ICC, of course, is the tribunal for that, and there were the special ICC tribunals. However, the international community fails to implement these tools, mainly because of the involvement of political considerations within the power of the legal institutions. This is one of the serious problems of international legal institutions today. Israel is a country that suffers most injustice and discrimination because of strong political interests. We all wish to live in a better world, and to achieve that goal, we have to formulate more and more the legal framework and a consensus as to the need to separate the professional international law from political involvement in the functioning of the international institutions. Our role as judges in democratic countries is to protect human rights, equality, and human dignity, and we are not allowed to shut our eyes even for a moment. Unfortunately, the dangers already exist. Our deep belief is that an independent and apolitical judiciary, both on international and national levels, is one of the most important guarantees for the protection of human rights and the prevention of future crimes against humanity.